Okay. I started with the owner.
Yes.
But then I consulted my running colleagues.
Yes.
And I told them for order.
Yes.
Let us finish so that when they respond, they will respond holistically.
That is okay.
To all the issues we have.
That is in order.
Yes.
Yeah, but do not repeat what your colleagues have ably presented.
I will be guided by military precision in terms of the points. Your Honor, I am making an application arising from the issues that have arisen in mitigation. And I am moving you under the Constitution and under the law, particularly the CPC, Section 216 of the CPC, Your Honor, which is very clear and certain, and it is a procedural law that guides and defines all of us. And it states, Your Honor, the court may, before passing a sentence or making an order against an accused person under Section 215, receive such evidence as it thinks fit in order to inform itself as to the appropriate sentence and order properly to be passed or made. So, Your Honor, we're dealing with appropriate sentence. The legal sentence is in Section 48(1) of ASECA, which says, Your Honor, is a fine not exceeding 1 million or imprisonment for a term. That is the legal sentence. But Your Honor, this court, in their wisdom, the legislators, and God is great, one of them is a legislator, in their wisdom say you can also go to the other law, like Section 216 of the CPC, so that Your Honor, as provided for in the preamble, and the preamble, Your Honor, the beginning words of the Constitution of Kenya says, acknowledging the supremacy of the Almighty God. Acknowledging. Constitution, which binds all of us, invokes God. And Kenya is a Christian country. You know what is the value we get from that? You go to Ephesians 4 verse 32, forgive one another as Jesus forgives you. That is exactly what we're reading with you, Your Honor. Now, the court process is over. The case has achieved its objective. But now we need to go more just than the law, because the law can be unjust. Justice is not necessarily just. And fairness is not fair. So we're saying we go beyond the law. How do we go beyond the law, Your Honor? We call for witnesses to confirm and verify the history you have been told that these people are old. Then you will make a holistic decision. So, Your Honor, we are not demanding too much. The law allows it. Your Honor, what is the constitutional underpinnings that inform that application? I will take you to Article 21, subclause 3 of the Constitution, which says, Your Honor, the state and all state organs, and the court is a state organ, and all public officers have a duty to address the needs of vulnerable members in society, including women and older members. Your Honor, I submit that the ages that you have been given in the mitigation, these accused persons are older members of our society. So we have a duty, a constitutional duty, at least to honor them and treat them, even when they are in mistake, we treat them with some softness. Let me say, then, Your Honor, I'll take you to Article 21(1), just very quickly, because they form the basis of my application. It is the fundamental duty of all state organs and state officers to respect, observe, protect, and promote, and fulfill the rights. When we read this, Your Honor, with Article 19(1), which says, human rights are an integral part of our society. and they inform the socio-economic framework. Your Honor, now this is where the Constitution comes in and tells you we can punish and we can reward. Your Honor, this case, and this I wish to commend all the stakeholders, and 4 stakeholders: the court, the EACC, the ODPP, the lawyers, and the accused. Your Honor, this is the only case which has complied with Article 50, Clause 2E of the Constitution. It's the only case of its kind. And that article, Your Honor, says to have the trial begin and conclude without unreasonable delay. Your Honor, this is the only case that has complied with those constitutional provisions. And who contributed to that achievement? All the stakeholders: the court, the accused persons, the lawyers, the ODPP, the investigators. They all participated. They have benefited from this case. Now, Your Honor, it is also time for the accused to benefit from behaving with decorum and facilitating the expeditious conclusion of this adjudication. Your Honor, this case has done its job objectively in terms of fighting the war on corruption, because it has changed the attitude of Kenyans in terms of the approach to the fight against corruption. So it has achieved its objective. Even if we were to jail them for 20 years now, it will not change that, to know that value. Already, it is a case which is a topical issue, it's in the public domain, and it has fundamentally engineered the war against corruption. So, Your Honor, I want you to take me to the Bible when Paul was going to Damascus. And the Spirit of the Lord appeared to him. Okay, I will go ahead, Your Honor, and proceed. I will give you that, but I will use the example.
No.
Your Honor, I'm saying this.
Allow Mr. Muteti. Muteti, I think you are saying we are not in church, isn't it?
Yes, please.
Sawa. It's okay. And I go to church, so I will give examples from the church. You know what I'm saying is this. These people here, we can turn them from Saul to Paul. They can be the best people who can fight corruption. And this is the opportunity. This is an historical moment for this court, Your Honor, to re-engineer the entire mentality and attitude in fighting corruption. Jailing people is not an answer. But finding them guilty is good enough because the court process has been followed. But after they are found guilty, Jesus told people, go sin no more. Your Honor, this court has power to do that. But I'm saying this, since these issues have arisen during litigation, there is need for this court to ground and verify some of the information that have been given. And how can we do that? The court cannot go to do that. It has to give an order to a probation officer to go and interview these accused persons so that we ascertain their actual age. We ascertain whether they have the families they have said they have. We ascertain whether this historical background, which is very impressive, they have given, is true. And then, Your Honor, we're not asking too much. Nobody will have any prejudice. If you give them 5 more days, we come before you next week, you remand them back at the Kileleshwa police station, they come back here, the probation officer gives a report, then, Your Honor, when you give your final determination, it is also grounded by an independent verification by a state agency, which is a probation officer. So, Your Honor, our application is not demanding too much. Kenya is a democracy, and we value all our institutions. We value the principle of separation of powers. We value the doctrine of legitimate expectation. We value respect for one another. And we are saying, Your Honor, in the context of the values in Article 10, that where this situation presents itself in the facts that have been presented to you by the mitigating lawyers, Your Honor, this is a good case to order for an inquiry within the meaning of Section 216 of the CPC, so that, Your Honor, when you make a finding and a determination, it is a determination that is holistic, complete, and then we will thank God for that, Your Honor. Your Honor, the other thing I want to raise is that This is also a case that raises several constitutional dilemmas, because it's a case that touches on all the arms of government: the legislature, the executive, and the judiciary. So Your Honor, in deciding it and taking into account the exceptional circumstances of their age, Your Honor, this is a case where you're going to make a point of departure from the normal judicial sentencing. Fourthly, Your Honor, and this issue has been raised, but I will just touch it, the principle of the guard against double jeopardy. Your Honor, I've read the charge sheet. In count 3, count 4, and count 5, the 3 accused persons are charged, and then the particulars are saying being directors of the third accused now, jointly and fraudulently acquired public property. So Your Honor, we are in this constitutional dilemma where if you punish the first and second accused by necessary implication, you have also punished the third accused, or vice versa. So Your Honor, that is something that will require that you need time to interrogate that issue so that you come up with a good final determination. So you were not asking too much, Your Honor, when we are saying they can be remanded in Kileleshwa police another 5-6 days so that you make these determinations holistically and come with a final analysis. Finally, Your Honor, from the evidence I've just crossed through the record very quickly, I have realized that there's a company called Listed Limited. This came out during evidence. It received 113 million. So Your Honor, which means even when it comes to the letter and spirit, the letter and spirit of section 48, 1D, you have to interrogate who received what. Because Your Honor, that will inform you on what to do in terms of who benefited, because a benefit as a penalty and a loss as a penalty. So that those issues have to be unpacked, Your Honor, and come out clearly that if you benefited, there's a penalty for the benefit. And if there was a loss of the company, after nested. It's called nested. Nested company. So Your Honor, what I'm saying is this: nectar. I will give you the proper, but it's something close to that. Your Honor, what we are saying is this, Your Honor, so that for you to bring the letter and the spirit of section 48 1B, then you have to appreciate that evidential burden of demonstrating what was the quantifiable benefit and what was the quantifiable loss. And that is what informs your sentence when you are assigning a particular sentence to people who are jointly charged. And then how do you separate the jointness so that there's no prejudice, since it formed one continuous transaction. And Your Honor, those are we're raising weight issues that require some time. And that's why we're beseeching the court. If Your Honor can invoke your powers under section 216, call for a pre-sentencing evidence or report, and then Your Honor, you will make up a complete decision. Your Honor, I'm also informed, and I believe it's correct, that the Supreme Court, when it was dealing with the petition number 56, consolidated with the petition number 57 of 2016, Francis Karioko Murwatetu and Mwangi versus the ODPP or the Republic, Your Honor, they expressed the fact that mitigation in sentencing is critical. And now the jurisprudence that underpins the criminal justice system following that Supreme Court ruling is that even matters are being brought back to the High Court, the lower court, for purposes of the sentencing, and the mitigation is a factor in that. So what we're saying is this: calling for evidence within the meaning of Section 216 of the CPC is well anchored in the Constitution, it is well anchored in the law, and it's also well anchored in our jurisprudence. I've given you the case that was decided by the Supreme Court, and Your Honor, I think it would be constitute a good practice. Your Honor, finally, we urge the court, to exercise leniency and give Your Honor, we were beseeching the court to give an uncustodial sentence in both after satisfying itself from the evidence. Your Honor, I only one copy of an authority which I want to round and do time for those conditions. My learned colleague is a guru in this area.
What is the citation?
The citation is Bonivas Okrosi Nisera and Sevas Kamande Maura, criminal appeal number 5 of 2018. Your Honor, I'm sorry, this is the only copy I have. I will give the court.
Let them look at it. Give it to the defense. Give it to the prosecution. Sorry.
First, yeah. Yes. Let me use it.
You're saying it's criminal appeal number?
Criminal appeal number 5 of 2018. And I will take you particularly to paragraph 1, paragraph 98 through to paragraph 103, where the issues are raised have been well articulated by the court. And the sentencing, well classified and clarified. Yes. Yeah. I will never give my learned because you are copying. So this.